We have for our next presentation, Emily Pontius from Frederickson and Byron. She's an employment law attorney, and I'll let her tell you a little bit more about herself.
Thank you, Jennifer, and thanks for having me here today. I really appreciate the opportunity. As Jennifer said, my name is Emily Pontius. I'm an employment attorney at Frederickson and Byron. Most of my practice is defending employers in litigation, advising employers with compliance issues, and conducting investigations. And most importantly today, I'm the mom of an 11-year-old who's competing in the mock trial competition over at the Polk County Courthouse, and he's wearing a suit and he's really adorable, and I'll show you pictures later if you want to see. So he'll grow out of it in about 3 months, so I'm going to probably make him wear it every day until then. Yes, yeah, he made an objection this morning. Yeah, it was really adorable. His face got all red, and then all the color drained from his face. It was really awesome. So I am going to provide updates on quite a few things. It's always difficult to know what things to talk about. I know that you all have a lot of different backgrounds and have deep knowledge in many areas, so I took my best bet at what you might want to hear about today. I'm going to provide updates on the EEO-1 form, the salary threshold for employees to qualify as exempt from the Fair Labor Standards Act, and discuss the current status of DOL's withdrawal of its interpretation regarding independent contractors and the joint employer rules. Then I am going to discuss some positive recent case law in the area of disability accommodation, and then also talk about preventing workplace harassment, because I decided that seems like a pretty timely topic right now, unfortunately. Okay, first the EEO-1. For those of you who are unfamiliar with the EEO-1, it's a form that must be completed annually by private employers and government contractors. The EEOC takes the data and analyzes it for employment patterns, including representation of women and minorities in 10 job categories. And then this data is used for, among other things, to support their efforts to enforce civil rights. So on July 14th, 2016, a rule was proposed that would have changed the EEO-1. Employers would have needed to also report W-2 pay data in addition to the gender and minority representation information that we just discussed. And then they also changed the due date from September 30th in this year, 2017, to March 31, 2018, because that would allow employers to use the year-end data that they don't have until the next year. The new data was to be used by the EEOC and the OFCCP in their enforcement efforts to address pay gaps that negatively affect individuals, including women and minorities. And this was motivated by research showing that approximately 35% of the gender pay gap cannot be explained by education level, experience level, industry, or occupation. So there was an opportunity for public comment on this rule, and as you might guess, commenters on the side of management expressed many concerns about revealing this information. They thought the rule would unfairly identify pay gaps as discriminatory because a lot of employees make personal choices that affect their salaries. For example, choosing not to apply for certain jobs, or choosing a less stressful job during a period of time where they may be raising young children, that sort of thing. And the EEOC said, that's okay, we'll figure it out, tell us everything, don't sweat it. And then on August 29th, 2017, which was more than a year after the proposed rule, the Office of Management and Budget used its authority under the Paperwork Reduction Act to initiate a review and also to stay the proposed rule. So the memo from OMB was issued to Victoria Lipnick, who is the acting chair of the EEOC, and said they had the authority to conduct the review because the EEOC provided employers with specifications they needed to follow and comply with in reporting this data, and they believe that that wasn't part of the public comment process, and therefore the paperwork burden estimates didn't include that information. So this also allowed them to do the review, and they stayed the requirements because, quote, OMB is concerned that some aspects of the revised collection of information lack practical utility are unnecessarily burdensome and do not adequately address privacy and confidentiality issues. So the OMB memo also stated that they had consulted with the EEOC before initiating the review and issuing the stay. It seems that the EEOC wanted to distance itself a little bit about how much they'd been consulted, because their statement said that they had urged a decision on the matter so that stakeholders would be aware of their reporting obligations, which makes sense. We were getting close to that September deadline that would have been in place had they gone back to the prior rule. So by way of a review, for those of you who are not terribly familiar with the EEO1, it has to be filed by all private employers who are subject to Title VII of the Civil Rights Act, that's the non-discrimination law, and they have to have 100 or more employees, it excludes state and local governments, primary and secondary school systems, institutions of higher education, Indian tribes, and tax-exempt private membership clubs other than labor organizations. Private employers subject to Title VII who have fewer than 100 employees also are in this net if they have an entire enterprise that employs 100 or more, and there's centralized ownership, control, or management. And in addition, most federal contractors with 50 or more employees have to comply with the EEO1. It just requires a workforce snapshot, payroll period in the last quarter of the year, and they have to report the number of total employees in each of the EEOC's 10 job categories by race, ethnicity, and by sex. And even though the new requirements to produce the W-2 pay data have been stayed, the employers still get the extra 6 months to file the EEO1. So there's a benefit from all of this. And that's just instructions on how employers file it. So in addition to the EEO1, there have been several other things that we started down a road towards in late 2016, and now we've sort of gone back the other way. And one of these things is the increased salary threshold for exempt employees. I think that by the time the EEO1 requirements were stayed in August 2017, we had all been really primed to expect the unexpected, but back in November of 2016, I think we were less prepared. I personally advised several clients on how to prepare for the new salary threshold for exempt employees, and I had one employer that I was working with who was a relatively small employer, and he was absolutely convinced that Trump was going to be elected. He was never going to have to do any of this. And no matter what I said, he wasn't going to take my advice. Turns out that he was a visionary. I should have listened to him. Needless to say, he's not called lately. That's okay, we were not really a great fit. So he also took kind of a rogue view on like the bills we would send him to. So in a lot of ways, it was not a really great fit. So the salary threshold for exempt employees was going to go up to $47,476, and we were all getting ready for that. So we know what happened. A Texas federal court issued a stay on November 22nd, 2016. And Judge Mazant, or Mazant, I'm not really sure, feel free to correct me, granted an emergency motion for preliminary injunction to stop the Department of Labor from implementing and enforcing the overtime final rule. Then on December 1st, 2016, which was the date that this was originally supposed to go into effect, the Department of Justice, on behalf of the Department of Labor, filed a notice to appeal the injunction to the Fifth Circuit. The Justice Department wanted the Fifth Circuit to affirm the Labor Department's authority to set a salary threshold at all for FLSA exemptions, because that seemed to have been put in a little bit of flux. And then as of June 30th, 2017, the case concerning the injunction was fully briefed at the Fifth Circuit. Then in August, back in Texas, Judge Mazan of the Eastern District of Texas granted summary judgment against the department. The court held the final rule's salary level exceeded the department's authority by focusing too heavily on workers' pay rather than on job duties to determine eligibility for overtime, and concluded that the final rule was invalid. Judge Mazant did not, however, opine on the lawfulness of a salary test. The DOL has filed an appeal of the district court order holding the prior overtime rule invalid, and it has stated it intends to request that the Fifth Circuit hold that appeal in abeyance while the Department of Labor undertakes further rulemaking to determine what the salary level should be. So that is where things stand right now, unless I miss something on my drive over. So in the meantime, we have a new Department of Labor Secretary. Alexander Acosta was confirmed by the Senate. And during the confirmation hearing, he stated his belief that the threshold should be somewhere around $33,000 per year. So we were at sort of I think, 23,660. The final rule would have been 47,476. And now the new labor secretary says around 30,000. Maybe that's where this should be. So on July 26, 2017, the DOL issued a request for information seeking public comments. And the comments were sought regarding the salary levels test, the duties test, the inclusion of non-discretionary bonuses, which was something that had gone into the previously proposed rule, and the salary test for highly compensated employees, and automatic updating of the salary level test. If you remember, that was one of the most controversial, is that this was going to be updated periodically based on the lowest level, or the region of the country that had the lowest wages. And that was a lot of controversy because that would have happened automatically. So the comment period ended on September 25th, 2017, and there were 165,000 comments. I have not read them, full disclosure. But the consensus, from what I've read from other people who have read them, is that there's not much support for completely getting rid of the salary level test to determine whether someone is exempt. But that the previous final rule just set that way too high and way too fast, which makes sense. I mean, the realities of trying to implement a raise like that, or to determine that people are not exempt, who were exempt, as many of you know, is really difficult to do. So they felt that really ignored the economic realities of the workplace. So in terms of setting the threshold, commenters were split between employer and employee advocates. The former suggested the low 30s as a good threshold, and the latter is going back for that 47,000 that was in the 2016 rule. So the department's next step is to review and come up with a proposed rule. And to the best of my knowledge, the most recent update is that the DOL confirmed on October 30th that it will undertake new rulemaking with regard to overtime. So for the time being, we are exactly where we were when this all started in March of 2014, when President Obama directed the Secretary of Labor to update the overtime regulations. So if history is our best guide, we are at least 2 years away from another final proposed sort of rule. And then when we do have a final rule, I will be very careful to implement the lesson I learned this time around. I'll advise employers how to prepare for the implementation, but I'm not going to promise that anything's actually going to happen. So my lesson has been learned. Okay. Yes, Stuart.
How will the court ruling impact the rulemaking? So in other words, did the government appeal the Fifth Circuit's rule? And if so, how will that impact the rulemaking in the Department of Labor?
I think the Department of Labor has appealed it, but they've asked it to stay in abeyance, to not rule on it. They've asked the Fifth Circuit not to rule on it while they determine where they think the final threshold should be.
2 years stay on the prior, on the 47.
I thought they appealed, and they're going forward with whether they have the authority to make.
I think that's right.
Okay.
Yes, thank you. Okay, cool. All right. So the next thing I want to talk about is the independent contractor administrator's interpretation, another thing that went one way and now is going back the other way. So in July of 2015, the Department of Labor issued an administrator's interpretation to address the misclassification of employees as independent contractors. The interpretation stated that most workers are employees under the FLSA's broad interpretation of what is an employee. So it further enumerated the protections not afforded to independent contractors, and of course that includes minimum wage, payment for overtime, unemployment insurance, and workers' compensation benefits. And the interpretation set forth the following factors to be considered. There's not a lot of change from this, but for those of you who aren't as familiar with it, factors include whether the worker's work is an integral part of the employer's business, whether the worker has an opportunity for profit or loss, the nature of the worker's investment in the company, and with the caveat that investment in tools and equipment is probably not enough, a worker's use of business skills and initiative as opposed to technical skills, the permanence or indefiniteness of the relationship, and finally the nature and degree of the employer's control. So the problem with all of these factors is that depending on what side you're on, you can probably find a lot of arguments in your favor, which is why this is such a sticky issue and why it's helpful to have any sort of guidance we can when taking a look at these issues. So the interpretation essentially provided a presumption that workers are employees, not independent contractors. And the DOL was then expected to use the interpretation to inform its enforcement efforts. And this was withdrawn in June 2017. So this sends a different signal that the DOL under ACOSTA will probably not prioritize independent contractor misclassification. ACOSTA has stated he will reinstate the practice of issuing opinion letters. So it's possible that he will replace the interpretation with an opinion letter on the same topic, likely with a different view. Practical effects are that, that I don't think this really changes most things for most employers, because if you are skating on the line, you're taking a risk, because these are sort of vague factors that we're looking at. It's still a case-by-case analysis. The central theme is control, and a written agreement is helpful, but not determinative. And most of us work for clients who like to stay on the safe side of things. So most of us have more employees than independent contractors. The DOL had also issued an interpretation in January 2016 establishing new standards for determining joint employment. The interpretation took the position that joint employment should be defined expansively, with the practical effect that all joint employers of an employee may be jointly and severally liable for compliance with FLSA requirements. All of a worker's hours are aggregated for the purposes of determining overtime pay, and an employee could look to the employer with deeper pockets in an action for back wages. So for some of you who may not be as familiar with what is meant by joint employment, most often we see this if there's a contractor and a subcontractor who's the worker's actual employer, franchisor, franchisee, user, supplier, lessor, lessee, parent, subsidiary, predecessor, successor. In my practice, what I usually see is a vendor or a third party who's the actual employer of the person, and then the worker is assigned to one of their clients. The administrator's interpretation was withdrawn in June 2017, which signals a step back from the expansive interpretation of joint employment, but we do not yet have any new DOL guidance. So a little bit of history here. Until 2015, direct control was required for joint employer liability. And then in 2015, the National Labor Relations Board decided joint employer status could be based on the right to exert just indirect control over essential terms and conditions of employment. So the board used its revised test to determine that Browning Ferris was a joint employer of recycling workers that were provided by a staffing agency. So there's been nothing new from the NLRB, at least as of last night, but on Tuesday of this week, November 7, 2017, the House passed a proposal to undo the expanded theory of joint employer liability for labor law violations. So that was just this week. This would amend the National Labor Relations Act and the Fair Labor Standards Act to require direct control over workers in order for there to be joint liability for labor law violations. And then on Wednesday, 2 days ago, the Senate confirmed Peter Robb, a management side labor lawyer, as general counsel of the NLRB. So experts believe that the Browning-Ferris Industries decision will eventually be reversed. Okay, I'm going to switch gears a little bit and talk about topics that I'm much more comfortable with, including disability accommodation, FMLA, discrimination, and harassment. I'm not comfortable with those actual things. I'm comfortable with these topics, with that caveat. So, most of you likely know that employers have to make reasonable accommodations for employees who are able to perform the essential functions of a job with or without reasonable accommodation, unless that accommodation would cause undue hardship for the employer. So the FMLA often comes into the picture when an employee has a condition that qualifies as a serious health condition under the let's go back here. Sorry. Okay. There we go. Often comes into the picture when an employee has a condition that qualifies as a serious health condition, but that also could qualify as a disability under the Americans with Disabilities Act. And the two especially intersect when an employee uses all of their 12 weeks of FMLA leave, but still can't come back to work. Very rarely, at least in my experience, and that's not fair because I only see it when things go poorly, very rarely is like, oh, I used up my 12 weeks, I guess I don't have a job anymore, thanks very much. That's usually not how that goes. At that point, the employer needs to determine whether the Americans with Disabilities Act requires some additional leave as an accommodation. So it's not the FMLA leave, it's just more leave to accommodate the employee's need. And then we have the question of how much is reasonable and what is an undue hardship. The FMLA says 12 weeks, that's what you get. The Americans with Disabilities Act just says a reasonable accommodation that doesn't cause an undue hardship. And the undue hardship analysis depends on what kind of an employer you are and what your resources are and what the employee's job is. So there's no hard and fast rules there. And the analysis is complicated by the fact that the employer has been able to stay in business for the last 12 weeks without that employee at work. So while I would never argue this because I'm not a plaintiff's lawyer, they would say, how much of an undue hardship can it be? You've been fined for the last 12 weeks. You haven't had to shut your doors. So why isn't it reasonable for this individual to have another 3 months off work in order to be able to come back and be a productive member of your workforce? I think it's a terrible argument, but I can see why they make it. So in most cases, employers just have to take a really wild guess and provide a little more time as an accommodation. And we use words like reasonable and case-by-case analysis, but we don't really know what we have to do. So we just kind of cross our fingers and hide under our desks and hope they get better really, really soon. So the good news is that we have some hope. A panel of 3 judges in the 7th Circuit decided the Americans with Disabilities Act does not require employers to provide even more leave after FMLA leave is exhausted. This decision is based on a very simple premise. This really shouldn't have been so hard, in my opinion. The ADA requires accommodation when a reasonable accommodation allows an employee to do the work. Leave does not do that. It means they are not at work. It doesn't allow them to do the job. That just has them not be at work. I don't think that's difficult. So if someone can't work, they cannot perform the essential functions, they are not a qualified individual under the ADA. The case, again, 7th Circuit, is Severson versus Heartland Woodcraft, and a prior 7th Circuit case, Byrne versus Avon Productions, opined similarly that not working is not a means to perform the job's essential functions. That puts it about as plainly as you can put it. So this is definitely a fantastic case for management. It is in the 7th Circuit. And one caveat too, the panel did say that a few days or even a few weeks might still be a reasonable accommodation, but a multi-month period is disqualifying. Of course, always disclaimers. I don't want to get myself in trouble, right? So most courts and the EEOC have ruled differently. The 7th Circuit covers only Wisconsin, Illinois, and Indiana, not us just yet. And certainly, I think the case will probably be appealed if it hasn't been yet. So for the time being, we still have to be very careful and continue a case-by-case analysis to determine what is reasonable. It's those words again. So I think that, you know, when you look at the requirements under the FMLA and the requirements under the ADA for a reasonable accommodation, the way I've always put that is, you know what, we never got to do an undue hardship analysis under the FMLA. We were not given the discretion to do that. So when someone is on FMLA leave, whenever anyone's on FMLA leave, it's always a good idea to document, if you're someone who has responsibility over this, to document how you handled that person's absence. Because the test isn't whether you went out of business because someone was gone. It's whether it was an undue hardship. It's not acceptable for someone else to have to do someone's job for a year. So I think that's the secret here, if there is one, to document how you were able to allow the person to be gone for 12 weeks and why it was an undue hardship. So, preventing harassment. This is a kind of excerpted from a presentation I've given a few times because the EEOC did a pretty important case study on preventing harassment. And I found it interesting then, and I think it's especially timely now. If you've read the news or read the tabloids at the supermarket, you know that the list of people who have recently taken a pretty big fall because they harassed people in the workplace is growing very quickly. From Roger Ailes, Bill O'Reilly, the Uber guy, the American Apparel guy, then Harvey Weinstein, Kevin Spacey. If you haven't watched the news, I'm afraid I'm going to hear a gasp, and you're all going to be really disappointed. Let's see, Steven Seagal, Jeffrey Tambor, the director of X-Men, even Jesse Jackson I saw. Apparently even NPR isn't safe for women when the senior vice president of news, Michael Oreskes, was there. So the thing is, though, that sexual harassment has been illegal for a while now. More than 30 years ago, the U.S. Supreme Court in Meridor Savings Bank versus Vinson decided that hostile environment workplace harassment was actionable discrimination under Title VII. And by way of review, to meet the burden to show hostile environment workplace harassment, you have to prove the harassment was severe or pervasive, created a hostile or abusive working environment, was unwelcome, and was based on gender. So in January of 2015, the EEOC created a select task force to study harassment in the workplace. The task force came up with findings and recommendations, and I'm going to go through some of them, and perhaps you will leave with a short to-do list, or at least a list of things to consider for your own organizations, because I think things might be changing a little bit. I think it's possible that it will be less and less acceptable to be skeptical of people who allege harassment in the workplace, and it will be more acceptable to report it. And this means that your legal department and human resources people need to be ready for that. And to be fair, even though I'm on the side of management, I don't think this is a bad thing. I think that when it all comes out in the wash, we're much better off if we identify and take care of people who are harassing and discriminating in the workplace. I think our companies do better. I think you make more money. I think your workers are happy, and you spend less money recruiting more new ones. So all in all, I think it's a good thing. Okay, so the task force and report. The task force was made up of academics in the fields of law, business, psychology, and sociology. It included 9 lawyers, about evenly divided between the good guys and the bad guys. Some were attorneys with nonprofit advocacy organizations. There was one corporate executive, a vice president at the National Women's Law Center, and also a program director at the Institute for Women's Policy Research. The study included testimony from more than 30 witnesses, public comments, public meetings, and closed working sessions. And they began with the facts, and these are the facts. In 2015, nearly 30 years after the decision making harassment illegal, the EEOC received 28,000 charges of harassment. 45% of those alleged sex harassment, 34% alleged harassment based on race, 19% alleged harassment based on disability, 15% based on age, 13% national origin, and 5% religion. The work culminated in a 95-page report that was authored by the task force co-chairs, who are commissioners with the EEOC. And the authors asked why there are still so many cases of sexual harassment. They said, is it okay to accept that some people will always engage in harassment and we cannot control how people behave? You know, from a defense perspective, after meeting and learning about many plaintiffs, I think we will always have harassment cases as long as former employees want to extort money, get revenge, and rationalize and or justify to themselves and others that a job loss was due to discrimination instead of poor performance. Not surprisingly, the EEOC did not mention my theory. But aside from that, I think they came up with some good recommendations. So the goal was to gain insight on how to prevent harassment in the workplace, but they did not confine their research, and I think this is important, to legally actionable behaviors. They dug a little bit deeper and looked at conduct that sets the stage for unlawful harassment. I think that we want to provide advice to help you avoid litigation. We usually put a lot of importance on what is illegal and what is not, but there's a lot more to it than that. A workplace doesn't go in one day from being a healthy place where people are nurtured and encouraged and to succeed to a place where there's unlawful harassment. So this part of the presentation is a lot about having the kind of workplace where harassment can't thrive. And a lot of the behavior that sets the stage is the kind of conduct that employment litigators would dismiss because it's not severe or pervasive. It doesn't rise to the level. We often quote that line about how Title VII is not a general civility code, and being a jerk is actually not illegal. But the thing is that when people are jerks in the workplace, that causes people to file lawsuits alleging unlawful harassment. And that's expensive, and it takes up people's time, and it takes up your resources. So even though some behavior isn't illegal, it's still worth talking about. I recently read an article that made a case for 2 words being the best indicator of a hostile workplace. And the 2 words were, that's just. As in, oh, that's just Harvey Weinstein, he does that, you know. As if sexual harassment in the office is like overactive air conditioning. It's just cold here, you know. So I think that's something that I've kind of attuned my ear to, even in my own workplace. When somebody says, "Oh, that's just so and so," they just act like that. It's like, that's probably not okay. Okay, so the key findings of the report is that first, most workplace harassment is not reported internally. In fact, the least common response to harassment is to report it. Usually the person avoids the harasser, tries to downplay the conduct, or attempts to ignore, forget, or endure it. 75% of those harassed never talked to a supervisor or manager about it. They report that they think they won't be believed, nothing will change, and they will be retaliated against it. We could see this as a good thing. If conduct can be ignored and there's no ill effect to the workplace, that's great. But according to this report, the cost of unreported harassment is actually quite high because it results in reduced productivity, increased turnover, and reputational harm. So an employee may not report harassment to his or her supervisor or the president of the company or to HR, but they'll probably tell their family and friends about it, and your clients and your customers may learn about it as well. And also, if it's unreported, you have no opportunity to correct it or remove the bad actor. They'll keep doing what they have been doing and likely cause further damage. So there's a compelling reason for preventing harassment. Excuse me. The report found that workplace culture is critical to preventing illegal harassment, and commitment and accountability at the highest levels of management are key to prevention, and that compliance training needs to change. This is one of my favorite sort of outtakes from this report from the EEOC, and I have used it several times when I'm doing training, most recently for a construction company, and it was a ballroom full of construction workers, and there was this one person in particular whose eyes kept kind of closing. And when I said this, that compliance training is not training to change your mind, it's training to keep your job, he totally woke up. Yeah, and he kind of listened after that, which I thought was really great. So, and I think it's important because I think that that we need to stress that harassment training is not an invitation to have a philosophical discussion about what a workplace should be or should not be, or what we should tolerate, or you know, just suck it up and move on with. But in fact, that you should just really keep your mouth shut unless you have something helpful to say if you're an employee. So, long story short, checking the box by showing a VHS video that was made in 1992 about not harassing people is probably not enough. Training needs to be done repeatedly, and it needs to be dynamic and tailored to your company. And even though we are talking quite a bit today about eradicating behavior that does not rise to the level of actionable harassment, training should clarify that some unpleasant behavior is not harassment. Like, for example, a negative performance review. That is not harassment. That is just a message that you need to improve your performance.
Repeated, I mean, regular basis, what?
Sure. I mean, I think that there are some employers who do, she asked about, you know, what do you mean by repeated, regular basis? I think some employers have them, you know, watch the video or talk to HR when they're first hired, and then nothing else happens for the next 20 years they are employed there. And that's not sufficient. It should happen on at least an annual basis. And from my perspective, I would say that if you can do it in shorter chunks and do it 2 or 3 times a year, that's even better. And not necessarily the same training modules every year, but mix it up a little bit. If you do computer-based anti-harassment training once a year and check the box that way, that's fine, but maybe the next time have someone come in and do live training. What I find so interesting in litigating employment discrimination cases is that when you bring in a manager and they're asked in a deposition, if they're not well prepared, if they're asked, oh, well, did you take any anti-harassment training? No, I don't remember that. No. And then you look back in their file, yep, every single year they dutifully went to their training, but somehow it never stuck. So you have the defense that, yeah, they took the training, the documents show that, but clearly it's not working if they can't even remember that they attended. So I do think it's important to do everything we can to make it something at least memorable. Because if they can't remember going to it, they're probably not going to remember what they were taught. So that's what I mean by repeated and dynamic and on a regular basis. And then I think that the focus needs to be on the middle management and frontline supervisors. And I think they need to be told exactly what to say and what to do if they personally observe or learn of harassment, and how to actually approach employees when they see behavior that does not meet the standards. You know, what exactly should they say to the subordinate who may also be a friend? who sends an inappropriate joke to their team, or who makes a comment that they shouldn't make in a meeting or in front of a client. What are they actually going to say? And for those middle management folks and those frontline supervisors, that is the hardest job, because these are people they work with day in and day out. They have relationships with them. They probably see their kids, all those sorts of things. What words are they actually going to use when they need to confront an employee? And if they don't know what they're going to say, they're probably not going to say anything, and then it will just get worse. So again, this is pretty texty for a slide, but one of the witnesses said, if I had limited assets to improve the climate of any organization, I would invest 95% of them in middle managers, because they make the difference in the day-to-day lives. When we train middle managers, we don't just train them about how to spot and address problem behavior. We teach them empirically sound things to do and say when an employee seeks them out to discuss a problem. So not just the person who sees or observes behavior and has to take care of it, but also what do you say when someone comes to you with a complaint? I think that, you know, the first 3 sentences that a manager says when they're confronted with a complaint of harassment are so key, because right then that employee is going to think, I'm in good hands, I did the right thing by reporting, or this is going to go awfully and I need to complain, or I need to go talk to an attorney. I think they really actually need to know their lines in a situation like that. So this is your to-do list, if you will, especially if part of your job is to manage the risk of employee litigation. So it's important to, you know, really reconsider the frequency and the timing and the methods of training that you implement in your organizations to try to prevent harassment and prevent discrimination. At least every once in a while, the trainers should be live and interactive. They should always be qualified. And it's also important to obtain feedback from the employees immediately after the training and follow up regarding the retention of the information and the effect on behavior. So this is, I mean, definitely advocating a much more high-touch approach to this type of training, but especially given the news lately, I think that your employees will appreciate that high-touch approach, and I think everybody needs a reminder. We all say things sometimes that we wish we had not said, and the more often we remind our employees to be their better selves, I think the better off we will be. So the touchstone motto for those of us who do employment litigation is that Title VII is not a workplace civility code, but we all also know that incivility is a precursor to more problems. And the good thing is that if you're focusing on workplace civility a little bit, and that's a positive thing. You know, instead of preventing harassment, we're promoting civility. A Harvard Business Review article reported that 25% of managers who responded to a survey and admitted to bad behavior said they were uncivil because their leaders were. The insurer United Educators recently published a research bulletin about preventing workplace harassment. And in the cases they handle, supervisors are the most frequent harassers, and the claims involving supervisors are the most costly. Certainly no surprise to any of you. So if an employee learns bad behavior from a supervisor, the lesson is that treating people badly gets you promoted to leadership. That's definitely not the lesson that we want to be promoting. And if we do an alternative message that promotes civility, that can be helpful. So they provided some examples of uncivil workplace behavior. I really hesitate to read this because I think I've done at least 2 of them already today. So, moodiness, negativity, no greeting, gratitude, or please, eye rolling, belittling. I would add to eye rolling is not something to do around your spouse either. It rarely goes well. Social exclusion, rude use of technology, interrupting conversations, and withholding information. So, you know, these are all things that I would label as really frivolous in litigation, but we see these behaviors in all cases. And when you go back, you know, as I have, and I'm sure many of you have, when you go back and look at the documentation, you go back and look at the emails, the history of a former employee who is now a plaintiff, you can see the progression of where this person became someone who would rather sue their employer than not. So uncivil behavior, I think if we can have less of it in the workplace, I think you will defend less employment lawsuits. So more on the price of incivility. In addition to the above, those who received uncivil behavior, about half said they intentionally decreased their work effort. Less egregious, people who are treated rudely are 30% less creative. I have no idea how one would measure that. I'm just passing this along. They have 25% fewer ideas, and the ideas they have are simply not as good. Even those who only witness incivility are affected. In one study, people who observed bad behavior performed 20% worse on word puzzles. Also, witnesses of incivility are less likely to volunteer to help others, even if the person who needs help was not the offender. So it sounds like, you know, kind of the idea that if you are in a workplace, you see that people in your workplace treat people poorly, you shut down. I'm only going to do my job. I'm not going to put myself out there. And that makes sense. Customers do not like to see your employees treated poorly either. In one experiment, participants witnessed one employee reprimanding another publicly. 20% of the people who witnessed the reprimand said they would continue to be a customer. 80% of those who did not see the reprimand said they would use the bank in the future. So there was a 60 percentage point drop just because they observed someone being reprimanded publicly. A study reported in Fortune magazine found that managers and executives spend the equivalent of 7 weeks every year mending relationships and dealing with the aftermath of uncivil behavior. 7 weeks. And these are people in leadership positions who probably can take more vacation than the average person. They could just go to Florida till Christmas, except they have to deal with uncivil behavior in the workplace. So lots of good reasons to make it a priority. So as far as a to-do list in terms of this, consider whether a respectful work environment policy or other civility measures might be appropriate in your workplace, and equip leaders and employees with the tools to identify and diffuse workplace incivility, and incorporate civility in performance evaluations. Because as we all know, if it's not in your performance evaluation, it's probably not something you're going to make a priority. So that concludes my presentation today. Thank you for your kind attention, and I will be available. I don't know where I am on time. About 10 minutes left? Okay. I can certainly take any questions if you have them. Okay. Oh, go ahead, sir.
Just an interesting question to see how people have been doing this. The last 3 months, I've been getting on average 2 requests under the ADA to bring a dog to work. Has anybody else seen that issue, or have you seen it in your practice, where more and more employees are asking to bring their pets to work because of the emotional support animal type objective that they're getting from their doctors, these excuses?
My understanding is that one of the things you can look at is whether or not the dog is specially trained. I think as far as the requirements under the ADA, that's something that the employee has to show and they have to document. But other than that, it's really, if they have a doctor's note and it's because of an actual disability, then that's something that you would want to consider seriously. Yeah.
Yeah, but I mean, we had one employee ask us that as well. You look at the expansion of emotional support animals under the Fair Housing Act, it's being brought into play, I think, a little bit more. And you're right about the training, but emotional support animals are different than service animals, and the level of training they need is a much lower barrier. Sometimes they don't even need to be identified. And so the question is it a reasonable accommodation? Like, in our analysis, it was a part-time employee that was only required to work 3-4 hours a day. So we were able to make the argument that you don't need the doctor. We basically figured out they didn't need to be in the office all day, so they didn't really need to bring the dog in for the 3 hours they were going to be in the office. But I think it is going to be something you see, Emily, because the expansion under the Fair Housing Act has made it an interesting question whether it's a reasonable accommodation, I would say.
And where I have seen this most often is I advise a lot of colleges and universities, and students want to have their comfort animal or emotional support animal live with them in the residence halls. And that's not 3 or 4 hours a day. That's all the time. So, yeah.
And how does that come out?
In some cases, they allow it, but it usually requires a lot more accommodating in terms of, if they have roommates or things like that, it becomes more difficult. And they do usually require some sort of doctor's note or medical documentation that it's necessary.
Well, just to echo that, what I do is I have a form that requests that accommodation that they have to fill out for an emotional support animal. Any request for an emotional support animal does require a psychologist to sign off on that, and there's case law that supports that. And just to echo what he said for the emotional support animal, I also saw the case law that doesn't require special training for those type of animals. It can be just as much as someone has their dog and they said, when they did training at home, that's all it takes. That's it.
I think that the doctor's note or something is so critical, because everybody could use some emotional support sometimes, So if there has to be a higher standard than just I feel better when my dog's around. So I think even if the requirements in the law put you in a situation where you feel like you're more and more at risk, there has to be some sort of threshold. So that the workplace doesn't feel like a kennel after a while. So, yeah.
And I would say if a doctor is willing to put their name and their license on the line for improper diagnosis, then let them do that. But as an employer, we need to accept that what we receive.
And I think it is acceptable to ask for a second opinion if you run into a doctor who seems willing to put that on the line more than once. So, yeah.
We had one question on the web, I think it was regarding earlier about employees leaving. If they went through their 12 weeks of leave, but they can come back part-time, is that acceptable?
That could be a reasonable accommodation to allow them to perform the essential functions of their job if it's not an undue hardship. Yeah. I would want to look at how much time they need. Is there an end date here? Because that also helps determine whether it's an undue hardship for that workplace. All right, thank you very much. Appreciated being here. Have a great afternoon.